What we will endeavour to do is to have both Nicholas and our next speaker available for questions together on the stage in the time that's available at the end of the session. So can I now please welcome Mr. Stephen Charles.
Thank you, John. Well, I enjoyed Nicholas's story of the two trials very much. Thank you for inviting me. It's an honour to be here talking to the Samuel Griffith Society. I should take you back to the Senate committees that had to consider Murphy's actions, but particularly to the second of them, because the second of them had two judges advising them, retired judges, as commissioners. One was John Wickham from Perth, and one was Xavier from Melbourne. And they heard all the evidence again. At the end of that, Wickham took the view that the allegation in relation to Breeze against Lionel Murphy was proved beyond a reasonable doubt. Connor, on the other hand, said that it couldn't be regarded as proof beyond a reasonable doubt, and you need to bear in mind this when thinking of it, Connor was a very well-identified Labour figure. He was very highly respected, but well identified as a Labour man. What he said was that in 4 years as a bench clerk to Victorian magistrates, in 23 years at the Victorian Bar, in 10 years on the Supreme Court of the ACT, and in 6 years on the Federal Court of Australia, I have not encountered anything comparable with Murphy's behaviour. It would be unfortunate if Parliament or the public were to gain the impression that it was accepted or normal judicial behaviour, and he said the judge was lending the prestige of his high office to an attempt to gain on behalf of an old friend some information which neither he nor his friend should have had. Now, these views are understood to have caused Senator Tait to change his view from that of the first Senate committee, and which led to the second committee taking a view by majority, Senator Bolkus was again the Labour man in the minority, that on the balance of probabilities, Justice Murphy could have been found guilty of misbehaviour serious enough to warrant his removal from the High Court. Now, as Nicholas has said, in the second trial, Justice Murphy did not give sworn evidence but made the unsworn statement. And the judge said then that he'd never suggested that Mr. Breeze speak to the magistrate who is hearing Morgan Ryan's case, and denied that he said to Breeze, "What about my little mate?" He said that he'd handled cases for Ryan's firm when he was at the bar, but he was not indebted to him and they were not close friends. Now, the judge's decision not to give evidence on oath, but to speak to the jury from the dock was indeed his right. But for a High Court judge to do so, in the terms Nicholas has said, caused astonishment and outrage among many lawyers, and it was immediately assumed that the judge could not return to the bench. But the judge was, in fact, acting on legal advice. Freehills were his solicitors, and Graham Kelly, then a partner, had said to the judge over a lunch, "I'm telling you absolutely straight, Judge, there are 3 critical pieces of advice. Mine is, do not give evidence. Peter's, that's Peter Perry, his is, do not call character evidence. And Clary Harder's advice is, do not call your wife because she gave evidence in the first trial. If you don't do those 3 things, we'll win this case. If you do any one of them, we'll lose." Now, that's advice was taken, and it's a bit difficult to take anything but the clearest possible admission of guilt from the course that was ultimately taken. Now, the view, obviously, was Ian Callanan, being a terrific cross-examiner, that any evidence he gave would be destroyed in cross-examination. But in any event, it was certainly thought by many that the judge after making an unsworn statement, could not resume his place on the bench. There were, in fact, other allegations of improper or inappropriate behaviour that continued to circulate in the press. There were claims that other judges on the High Court would not sit with Justice Murphy, but nonetheless he resumed his seat. And in the light of the continuing criticisms, the Federal Labor Hawke government decided to set up the Parliamentary Commission to inquire and advise whether any conduct of the judge had been such as to amount, in its opinion, to proved misbehaviour. Now, Section 72(2) of the Constitution provides that justices of the High Court shall not be removed except by the Governor-General in Council on an address from both Houses in the same session, praying for such removal on the ground of misbehaviour or incapacity. And in 1986, there was little or no direct authority on what those words actually meant. The leading authority on parliamentary government at the time was Dr. Alpheus Todd, and he wrote that behaviour in this context includes the improper exercise of judicial functions, secondly, willful neglect of duty, or third, a conviction for any infamous offence, by which, though not connected with the duties of his office, the offender is rendered unfit to exercise any office or public franchise, and in the case of misconduct outside the duties of his office, the misbehaviour must be established by a previous conviction by a jury. So that statement, and you have to bear in mind that the words during good behaviour, or the Latin form of them, came into being in 1690 or 1700, the time of the Glorious Revolution, and bearing in mind that James II had been so enthusiastic about removing any judge at that time who did anything contrary to his views. And one of the aims of the Glorious Revolution was to procure the separation of powers and the independence of judges. Now, Todd's statement had been repeated in many textbooks. At the time, all the editions of Halsbury's Laws of England, Quick and Garran, supported it. The Judges' Council, who was David Bennett, QC, had given advice on the narrowest meaning of proved misbehaviour, to the effect that private misconduct falling short of a criminal offence could never amount to misbehaviour. At the same time, the First Senate Committee had been advised by Bill Pincus, QC, of the Queensland Bar, in terms which supported each House of Parliament having freedom to decide what private misconduct constituted misbehaviour. The Solicitor General, Gavin Griffith, had also given advice roughly to the same effect. In any event, Parliament then passed the Parliamentary Commission of Inquiry Act, which set up the Commission. And the Commission was required to conduct its hearings in private and to report by 30th of September of that year. And the Act required the Commission to consider only specific allegations made in precise terms. It was required not to consider issues dealt with in the trials leading to Justice Murphy's acquittal, or his guilt or innocence of those charges, or whether the conduct to which those charges related was such as to constitute proved misbehaviour. The judge was not to be required to give evidence on a matter unless the Commission had before it evidence of misbehaviour sufficient to require an answer, and the Commission had to give the judge particulars in writing of that evidence. And the Commission was given power to summon witnesses and issue search warrants. Now, the three commissioners appointed were all retired judges, and they were all very distinguished. Sir George Lush from Melbourne, Sir Richard Blackburn from Canberra, and the Honourable Andrew Wells from Adelaide. I was briefed to assist the Commission with Mark Weinberg and Alan Robertson, and the Judges' Council were Roger Giles, Marcus Einfeld, and Annabel Bennett. Now, Justice Murphy immediately applied to the High Court for an interlocutory injunction to prevent the Commission sitting, on grounds that it did not authorise any investigation to be made of him, and also that Mr. Wells was disqualified from taking part in the inquiry. Shortly after the age tapes had been published, which was one of the things that started the investigation and the furor surrounding Justice Murphy, Justice Michael Kirby, then chairman of the Law Reform Commission, had been reported as saying that the discussion between the solicitor and Justice Murphy about the appointment of someone to a high position in the New South Wales Public Service and his agreement to lobby the politician who would make the appointment were the sort of thing that goes on all the time in judicial circles, and that the intervention of judges in such matters was part of the netherworld of the legal arena. Now, Justice Wells had been reported to have said in court in an unconnected trial the following day that the article not only imputed corruption to judges, but implied that from time to time they were willing to act in flagrant defiance of constitutional principles governing the separation of powers. And Justice Murphy's counsel claimed that Mr. Wells, now retired, would be unable to bring an impartial and unprejudiced mind to the inquiry. Well, the High Court rejected the application to stop the Commission out of hand, and I need to read part of what it said on this ground to you. The remarks made by Mr. Wells were made long before the inquiry was set up and were not made in reference to the plaintiff or his conduct, but to rebut the assertions attributed by the writer of the article to Justice Kirby. We, of course, do not know whether Mr. Justice Kirby did make remarks to that effect. However, in our experience, it would not be right to say that judges commonly intervene to influence the making of public service appointments, or that there is a practice inherited from England whereby judges descend into some nether shady world of dubious behaviour. The remarks of Mr. Wells amount to no more than a denial that judges, to his knowledge, engage in conduct of the kind allegedly described to Justice Kirby, conduct of a kind which Mr. Wells regarded understandably as contrary to accepted standards of judicial behaviour. It would be preposterous to hold that the expression by a judge of generally held views as to the standards of judicial propriety should be thought to disqualify him from acting in a judicial capacity. Now, the brief that was given to the three counsel assisting in late June of 1986 was an unusual one, if not unique, because we were told that the Act had been passed. We were given very little information other than a few press cuttings. We were well aware of the proceedings in the Senate committees that had taken place and the trials that the judge had faced, but we were told simply that it was our function to investigate and to inquire into this material. And so we set to work. We went to many people in Sydney to talk about all these matters, and I can assure you that in a large number of cases we departed with a large flea in our ear. But the fact remained that since the judge had been acquitted on the charges on which he'd been tried and no other convictions existed, the question immediately arose whether the facts alleged in these documents were capable of constituting misbehaviour. And so the Commission then heard argument on this question for some days. Counsel for the judge, Roger Giles in particular, argued that misbehaviour in section 72 extended only to conduct falling within either or both of two categories: conduct in office, as that expression was understood at common law, and secondly, conduct not pertaining to the holder's office amounting to an infamous crime, i.e. of a felony at least, of which the holder had been convicted. And they argued that since none of the allegations that we produced asserted a conviction, they could only be supported if the facts asserted amounted to misconduct in office. And they argued that all, or at least most, of the documents would be found to fail to allege facts capable of constituting misbehaviour. In response, we argued that Section 72 had presented to the Australian nation a provision that was and was intended to be a new creature, that the authorities relied upon by counsel for the judge didn't make good the proposition they were said to establish, and that even if they did, the Constitution had by necessary implication rejected it, and the word misbehaviour should receive its natural meaning in the legislative and constitutional context in which it appeared. Now, we argued, in effect, that misbehaviour meant conduct which would be reasonably regarded by senior judicial officers as immoral and disentitling the judge to continue to act. And that was roughly what the three commissioners found. Their judgments were reported, and each of them rejected the arguments pressed by Justice Murphy's counsel. Sir George Lush said, "It's for Parliament to decide what is misbehaviour, a decision which will fall to be made in the light of contemporary values. The decision will involve a concept of what, again in the light of contemporary values, are the standards to be expected of judges of the High Court and other courts created under the Constitution. The present state of Australian jurisprudence suggests that if a matter were to be raised in addresses against a judge which was not on any view capable of being misbehaviour, calling for removal, the High Court would have power to intervene if asked to do so." And Sir Richard Blackburn made remarks to the same effect. Commissioner Andrew Wells said, "The issue raised by Section 72 would thus appear to pose questions of fact and degree. Somewhere in the gamut of judicial misconduct or impropriety, a High Court judge's conduct outside the exercise of his judicial function that displays unfitness to discharge the duties of his high office can no longer be condoned and becomes misbehaviour so clear and serious that the judge guilty of it can no longer be trusted to do his duty. What he has done then will have destroyed public confidence in his judicial character, and hence in the guarantee that that character should give, that he will duty expected of him by the Constitution." Now, there were then, in the course of 2 or 3 months, some 15 charges that had been served on Justice Murphy, or which had been prepared at the time the Commission was adjourned. And we had considered and rejected many other allegations, such as, for example, the allegation that Justice Murphy was a Soviet spy. Now, a sample of those remaining, and I'm only giving you a shorter version because they all included particulars as the Act required. 1, in December 1979, Lionel Murphy attempted to bribe Commonwealth Police Officer Donald William Thomas to provide covert information relating to or acquired by the Federal Police to unauthorised persons within the Labour Party. 2, between April 1980 and July 1981, Murphy agreed with solicitor Morgan Ryan, his longtime friend, to make inquiries with a view to determining whether 2 federal police officers could be bribed or influenced to act contrary to their duty as police officers. 3, during Murphy's trial in 1985, he knowingly gave false testimony regarding the effort he had made on behalf of Ryan regarding his criminal proceedings. 4, in 1979, Murphy agreed with Ryan to speak to New South Wales Premier Neville Wran for the purpose of procuring the appointment of Wadim Jegaro to the position of Deputy Chairman of the Ethnic Affairs Commission of NSW. He subsequently spoke to Wran and told Ryan that Jegaro would be appointed. It's alleged the conduct amounted to misbehaviour by entering into an agreement to influence the making of a public service appointment and actually intervening to achieve that purpose. 5. In 1982, Murphy asked District Court Judge James Staunton to arrange an early trial for Ryan on certain charges pending in the District Court. By doing so, it is alleged, Murphy abused his office as a judge of the High Court and further, or in the alternative, improperly attempted to influence a judicial officer in the execution of his duties. 6. In June 1985, Murphy, while on trial, deliberately understated the frequency of his contacts with Ryan and misstated the nature of their association. Alleged this amounted to knowingly giving false testimony and constituted conduct contrary to accepted standards of judicial behaviour. 7. In January 1980, Murphy agreed with Ryan that Murphy would make or cause to be made representations on behalf of interests associated with Abe Saffron to persons in a position to influence the awarding of a contract for the remodelling of Sydney's railway station. Murphy did so while knowing Saffron to be a person of ill repute. Now, proof of these matters would have involved calling evidence from a number of people: Donald Thomas, Morgan Ryan, Abe Saffron, Neville Wran, and Judge James Staunton, as well as Clary Breeze. We would have had to prove that the statements made by Justice Murphy in his trials, and in particular his unsworn statement to the jury, had been false, and any lack of truth on which we relied. Well, would the Commission have found the judge guilty on any of the charges laid? All involved in the Commission were bound to secrecy by the terms of the legislation which terminated the Commission. And it is only Parliament's recent decision to release the papers of the Commission, including the 15 draft charges, which makes comment on them now possible. The charges stand as mere allegations of matters occurring well over 30 years ago. But there were, I think, reasonable prospects of at least some of the charges being made good by evidence to the Commissioners. The Judges' Council would certainly have alleged that charges 3 to 6, among those I've mentioned to you, involved issues dealt with in the two trials, but we thought that there were proper grounds for pursuing those charges. If anyone were to describe any of the charges as being the sort of thing that goes on all the time in judicial circles, like charges 4, 5 and 7, well, the High Court had already made emphatically clear its attitude to any such proposition. And if an attempt had been made to ask that court to hold that the charges were not capable of leading to removal, I think that application would have failed. Well, the question remains, what would have happened if the Commission had reported to Parliament that, in its view, any of the charges had been proved? Although two of the Commissioners had stated their view that the High Court retained a role to intervene to prevent Parliament from removing a judge if grounds for action were not on any view capable of amounting to misbehaviour, the real question was whether Parliament would be persuaded to act. The reality was that both Houses of Parliament were then controlled by the Labour Party, and many in that party were absolutely furious that the government had set up the Parliamentary Commission at all. All that the Commission was entitled to do under Section 5.1 of the Act setting it up was to report to Parliament its view of whether any conduct of the judge had been such as, in its opinion, to amount to misbehaviour within Section 72. And after so of course, it remained a question, whatever the Commission decided, for Parliament to decide whether it was going to act on the Commission's report. Now, after the hearing of argument, the judge resumed sitting on the High Court. His counsel informed the Commission that the judge had an advanced state of cancer in its secondary stages, that there was no cure and no treatment. The hearings of the Commission were adjourned sine die, and the government then, however, supported the judge's right to sit and passed legislation which repealed the Act setting up the Commission of Inquiry. The views of the Commission were published in the Australian Bar Review under the title Murphy and Lush, and their views have been adopted since by the Parliamentary Judges Commission of Inquiry in Queensland under Sir Harry Gibbs in 1988 and 89, and also considered by the Honourable Peter Heery in his report to Parliament concerning the conduct of Vice President Lawler. And they've also been approved in Odger's Australian Senate practice, which also in the chapter on the point said that the British and American authorities accept the wider view of misbehaviour. The Commission was terminated before any evidence had been called. Now, friends and supporters of the judge, like Professor Blackshield, have characterised the charges as containing no surprises or fresh revelations and just muck coming out of the Age tapes and the National Times articles. And the thrust of his comments is that the 15 charges would not have led to any action by Parliament. Well, the fact remains that the High Court's comments on the application to remove Commissioner Wells for bias show that the 6 High Court judges dealing with that application plainly shared Mr. Wells's views on corruptions and the standards of judicial propriety. After the charges were delivered to the Judges' Council, lengthy cross-examination of some of the potential witnesses was forecast. One of the Judges' Council said to me that the cross-examination was going to take years. Well, we were supposed to report by September the 30th, and this was August. The Commission would almost certainly have been forced to fix draconian limits of the time of cross-examination, and that may have led to claims of unfair treatment and denial of natural justice. So far as I'm aware, the Commissioner's reasons haven't been considered by any appellate court or the High Court. The Judges' Council did make an application to the court seeking to challenge the validity of the charges, but the court rejected the application out of hand and sent it straight back to the Commission saying, we'll wait until the Commission decides its views. The absence of later appellate consideration leaves untested the Commissioner's reasons relating to the meaning of misbehaviour and proven in section 72. The fact that Alpheus Todd's views had been universally accepted before the Commission still leaves it possible for that court to arrive at a different view. And another undecided question is just what role the High Court can play in the removal of a state or federal judge. In America, the Supreme Court in 1993 took the view that that court did not have any such jurisdiction. The procedure for removal of a federal judge is now covered by new legislation in 2012, the Judicial Misbehaviour and Incapacity Parliamentary Commissions Act, which, among other interesting things, provides, it again makes no definition of misbehaviour, but interestingly, it provides for open hearings rather than in-camera hearings.